Now, we were in the courtroom. Give us a recap of what happened.
Well, today what we wanted to do was challenge the statements that were given by Mr. Munt. Specifically, once somebody, under the law, once somebody asks for an attorney or says, maybe I should have an attorney, our position is the officer at that point can no longer ask questions of what happened, didn't happen. They have to clarify right then, do you want an attorney or don't you? And in this case, our position is that was never done until 15, 20 minutes later. So I'm fairly confident that the court will suppress the evidence. I can't say for sure, obviously, but when the CD is listened to, when the judge listens to the CD, it's very clear. And the officer is very honest about what was said. So I think just the testimony alone, I'm hopeful will get that statement suppressed.
Now you mentioned what you're using for defense today.
Right, and what we're saying is, at the time this occurred, that Mr. Munt felt the only way he could save the kids from what's been documented in some things, somewhat abusive on her part. He felt at the time the only way to stop that abuse is to shoot her. Not saying that was deserving or justifying it, but in his mind that was the only way to prevent further abuse.
So is that a mental illness?
Yes, it is. Yep.
Now he did pass
He's had a competency test, and the competency test was whether or not it's two-pronged. One is if you're able to converse with your attorneys, if you know what's going on. I know that the judge isn't a cucumber type thing, which obviously we're not challenging that. And the other is whether at the time he was competent. So number one found he was, and we're not in agreement with test number one.
And where do you hope to go from here?
We'll be looking at the mental, his mental history, what happened exactly on that date, what he was thinking, and those types of things through someone else.
I'm good.